Hello and welcome to another episode of Insurance in Canada. I'm your host, Rick Pereira. So glad you can join me. So, on today's episode, we're looking at three stories. Our first story we're going to look at today are restrictions on transporting certain types of electric vehicles on BC ferries. Our next story involves the opposition party in Saskatchewan pressing the government to remove the requirement for vehicle inspections for certain types of vehicles entering Saskatchewan. And our last story for today will look at a case in Ontario, case where the plaintiffs' lawyers try to circumvent certain rules when it comes to placing lawsuits and trying to insure the insurance company directly. So, without further ado, let's get into insurance in the news. So our first story for today comes from British Columbia and some requirements Transport Canada has imposed on BC ferries when it comes to the types of electric vehicles that can be transported on the ferries in BC. So let's take a look at this article from Ollie Herrera. Transport Canada forces BC ferries to prohibit damaged EVs. BC Ferries is now prohibiting damaged electric vehicles from sailing on board its vessels due to a Transport Canada regulation preventing them from being transported. For towing companies on Vancouver Island, there's no shortage of work handling electric vehicles. We probably handle 10 to 15 EVs a day, says Don Affleck, owner of Peninsula Towing. And considering this is just Vancouver Island we're talking about, not all of British Columbia, that's quite a number of EVs that they're dealing with in just a day. Jonathan Vipond, owner of Salt Spring Island Towing, says we handle between 2 and 4 EVs a week, and Salt Spring Island is a much smaller island than Vancouver Island, so to be dealing with that many a week is quite a bit just for a small island like Salt Spring. However, towing companies may now face a harder time accepting jobs involving electric vehicles. The two towing company owners recently received a memo from BC Ferries outlining that many electric vehicles will no longer be allowed to sail on board its vessels. It's a problem brewing. There's a storm brewing, says Affleck. So the change is electric, hybrid, and alternative energy vehicles prohibited from charging at BC Ferry properties and on vessels. I don't think any BC Ferry now or in development has any ability to charge an electric vehicle while en route anyways. Vehicles with minor or cosmetic damage that clearly doesn't affect the battery or wiring are allowed at the discretion of the vessel master provided they are being driven under their own power. Vehicles with major damage including exposed batteries, fluid leaks, or wiring issues are not able to be transported. Electric vehicles that are being driven like those on tow trucks aren't allowed on board. BC Ferry says that due to changes by Transport Canada, electric, hybrid, and alternative energy vehicles are prohibited from charging on board. Vehicles of minor, we just read that. BC Ferries does not say full-size commercial car carriers transporting operable and undamaged used or new vehicles to dealerships will be permitted. There's no way for me to tow it over on a flatbed tow truck because their wording stated if it is inoperable, which is going to be on a tow truck, I can't take it on board their vessels, says Vipond. BC Ferries, which is regulated by Transport Canada, say the change is meant to prevent risks associated with EV batteries to ensure the passenger and crew safety. BC Ferries has recently updated its policy around the transport of electric vehicles due to potential fire and environmental risks associated with damaged lithium-ion batteries. The two owners agree that BC Ferries took a step in the right direction to prevent fire risks on board, but there's still an issue in transporting the vehicle. Vipond says he is worried that EVs will eventually combust on Salt Spring Island, damaging property or causing wildfires. The problem is they put something in place that all of these vehicles are already on the Gulf Islands, and there are a lot of them. They need to have means to get repaired. Affleck says he may have to reject jobs in the future since he can't find a suitable location or or to properly dispose of electric vehicles. There isn't a recycler that we are aware of, and I've called a number of companies up and down Vancouver Island, said Affleck. No one is aware of any recycler that deals with hybrids or EVs. We understand there is one in Vancouver. Now we're back to the same problem again. So it's understandable why Transport Canada would want to take this position when it comes to electric vehicles, and it's mentioned in the article the problem with the lithium-ion batteries. Lithium-ion batteries, there have been multiple stories about these batteries combusting when they are damaged, even when they are apparently undamaged. These batteries have a, like I said, tendency, but there have been many reports of these types of batteries just combusting on their own. And if you haven't seen any videos when it comes to electric vehicle battery fires, let me tell you, they are quite extreme. They are very, very difficult to put out. They burn very, very hot. The research I've done saying a normal conventional car fire burns between 600 to 800 degrees Celsius. A electric vehicle fire can burn around 1,000 degrees Celsius. And because the fire is being caused by a chemical reaction within the battery, it's, like I said, it's very difficult to put these electric vehicle battery fires out. The amount of water you need in order to do so is much greater than it is for a conventional vehicle. For instance, from the research I've done, it typically takes about 1,800 to 3,800 liters of water and foam to extinguish a fire on a conventional internal combustion engine vehicle. However, when it comes to electric vehicle fires, it's somewhere between 10 and 30,000 liters of water, with some instances of there being required 75,000. In fact, there was another story that I found back in 2021. It was a fire on a Tesla. It required 113,000 liters of water to put out the fire and to cool the battery to the point where it's not going to reignite, because that's another issue when it comes to electric vehicle battery fires. Trying to put the fire out, and B, trying to prevent the fire from reigniting. That is a severe risk when it comes to lithium-ion battery fires. So if such a fire occurred on board a vessel, there's no way to put it out. There's not enough equipment, resources on a vessel to put out that kind of fire. And there was an example last month of a vessel, the Morning Midas. The Morning Midas is what's called a ro-ro vessel, a roll-on, roll-off vessel. So it transports vehicles from one destination to another. And these vehicles, you drive onto the vessel, and when it gets to the destination, you drive them on. So roll-on, roll-off, or ro-ro. It was transporting vehicles from China to Brazil, including a bunch of electric vehicles, and a fire started on one of the car carrier decks that had the electric vehicles, and they were unable to put out the fire. So they had to abandon the vessel. So this is a photo of early when the fire started early. Eventually, you can see here one of the latest or last photos of the vessel itself, how it's all charred in the back. So here you see in the back, it's relatively clean, if you will, but here, one of the last photos, yeah, it's all charred. You can't use CO2. Sprinklers aren't going to do anything. Halon, forget it. Nothing is going to work to put out that fire once it gets lithium-ion battery fire once it gets going. And once it gets going, it's just going to spread to the other vehicles. And if it spreads to other electric vehicles, eventually their batteries will go off as well, and will just keep burning and burning and burning. In fact, last week, they tried towing the vessel back into port because it was just adrift for a week or two, and they tried towing the vessel back, and eventually the vessel sunk. And it's sitting in about 16,000 feet of water right now on the ocean floor, so that's not going to be recovered anytime soon. But that is the dangers when it comes to electric vehicles. Is yes, they're looking at those vehicles in the article and the Transport Canada regulations about damaged electric vehicles. Because as we saw last week, when we looked at that article from Vancouver about how little damage is required to total a electric vehicle, and how not a major impact is required to do damage to the battery pack. That's the big risk when it comes to potential damage to the battery pack, is the battery pack going off, igniting, self-igniting, and causing this huge fire. So understandable. The thing is, it's obvious when it comes to a vehicle, electric vehicle that's been in an accident. However, damage to the battery pack is not always going to be visible. The battery pack is usually, for most electric vehicles, stored underneath, usually the back seat, in a large area underneath the back seat. So without doing a lot of work trying to visually inspect the battery pack, that's not practical in order to allow these vehicles on board. So it's a risk that vessel owners take when take these types of vehicles on board. And just because it's a brand new electric vehicle does not mean that there isn't the risk that the battery pack is going to ignite on these electric vehicles. So it's good they're taking these precautions, but just because you're not allowing the worst case scenarios onto your vessel doesn't necessarily mitigate the risk, in my opinion, when it comes to electric vehicles. So, and as the electric vehicles become more and more popular, theoretically, and as the federal government has just put the mandate to go all electric by, I believe it's 2035, I wonder how organizations like BC Ferries, as well as other ferry corporations throughout Canada, is going to have to deal with the fact that these vehicles do have that risk of just igniting on their own. So I guess that's something we'll have to keep an eye on as the years progress, as we move towards that 2035 date, if that ever happens. So that's the other issue. We talked about last week the one issue with electric vehicles, from the insurance aspect, how very minor damage could cause a vehicle to be totaled. The other aspect comes insuring these electric vehicles is the fire risk. So we had a client in our office who went on a trip. He had a Ford Mach-E. The vehicle was only 4 or 5 months old. He only had about 4 or 5 months. He parked it at a park and fly near Pearson Airport in Toronto. He was gone for about 7 days. When he came back, got back to the park and fly lot, went to where his vehicle was, and it was just a charred mess was all that was left of his vehicle. It was just the frame of the vehicle that was left because the battery ignited and the entire vehicle was gone. Like I said, it was just the frame of the vehicle that was left. Even the tires, all the 4 tires had melted. That's how intense that fire was. So like I said, just because it's a new vehicle does not mean that the risk is not going to be there for the danger of a fire on an electric vehicle. But once again, it's going to have to be something that's going to be taken into account in the future when it comes to insuring electric vehicles. How do we properly address the risk when it comes to these types of vehicles? Not only having higher claims costs because of the propensity of these types of vehicles to incur total loss-worthy damage on minor impacts, as well as the fire risk itself. There's other factors when it comes to increased claims costs when it comes to electric vehicles, but maybe we'll talk about that in a future episode. From Saskatchewan, Saskatchewan opposition urges government to remove requirements on used vehicles. It's time for inspections to be scrapped, it suggests. From Josh Recamara, Saskatchewan's opposition NDP is calling on the provincial government to remove the requirement for mechanical inspections on used vehicles purchased outside the province before they can be registered and insured. CBC reported if the vehicle is insured and deemed roadworthy in another province, that should be enough to get it on the road here, said Hugh Gordon, the NDP's critic for Saskatchewan Government Insurance, SGI, during a news conference Thursday. It makes no sense that a driver who finds a great deal on a vehicle should face extra costs and red tape. Under current SGI policy, used vehicles brought into Saskatchewan from another province must be inspected at an SGI-approved facility before registration. The cost of inspection varies based on the vehicle size and condition. Jared Callan, an operator with Midas Auto in Regina, said the average cost is just under $200 according to the report. Callan said he does not support the proposal to remove the requirement. I think there should be more safety, not less, he said, pointing to Manitoba's policy requiring inspections before any vehicle sold, regardless of where it originates. And I'm more on the side of the Midas owner here that seems like a bit of a stretch that just because a vehicle was on the road in another province that somehow makes it automatically roadworthy in Saskatchewan. I mean, here in Ontario, unless a vehicle is being sold, either new, not new, but being sold for used either through a dealership or privately, that vehicle is going to have to go through a safety inspection in order to be transferred to the new owner. However, that's about it. It's not like there's annual inspections for vehicles here in Ontario, and there's no such annual inspections for vehicles anywhere else in Canada as far as I know. So, like I said, you could have had a vehicle here that's here in Ontario that's been on the road for like 12 years. Doesn't necessarily mean that it's, the safest vehicle. It's operational. Whether it's safe or not, that's up to debate. So importing that vehicle into Saskatchewan just on the assumption that that vehicle was insured and on the road in Ontario, like I said, that does not necessarily mean that it's still safe to be on the roads of any other province. That's just my opinion, though. SGI said the inspections are in place to promote road safety and reduce insurance-related fraud. In a statement, the insurer said the requirement helps identify vehicles that may have been written off in another jurisdiction or involved in collisions that were not reported. Mandatory vehicle inspections are also ensure that rebuild total loss vehicles and vehicles involved in unreported collisions in another jurisdiction are properly repaired before returning to the road. So here in Ontario, if a vehicle is involved in an accident and is declared a total loss, the insurance company will inform the Ministry of Transportation in Ontario that will rebrand the vehicle as a salvage vehicle. And salvage vehicles cannot be plated. So they are no longer legal on Ontario roads. They have to be repaired, gone through an inspection to confirm that they are safe to be on the road, and then it can be rebranded as being rebuilt. So trying to pass that vehicle off in a different jurisdiction. Hopefully the other jurisdictions such as Saskatchewan will notice on the vehicle ownership from Ontario the salvage or rebuilt branding to indicate that this vehicle was involved in a total loss. I'm quite sure the other provinces have a similar type of branding to indicate that those vehicles from that province were also involved in total losses. Maybe they do, maybe they don't. But like I said, it's something that really you would think would be on a national level to make sure that these types of vehicles aren't being passed off in other jurisdictions when they have been declared a total loss in one particular province. SGI also cautioned that removing the requirement could increase risk of Saskatchewan becoming a point of entry for unsafe or stolen vehicles to be registered and resold. In 2024, SGI processed 32,200 inspections of non-commercial light vehicles brought in from outside the province, a slight increase from 31,500 in 2023. The NDP argued that the current rules create inconsistencies between vehicles bought within the province and those brought in from elsewhere. Gordon pointed out that there is no inspection requirements for older vehicles already in Saskatchewan. You can buy a 20-year-old vehicle in the province and register it without an inspection, but a nearly new vehicle from a neighboring province requires one. That makes no sense. At least in that 20-year-old vehicle in the province of Saskatchewan has some history in the province of Saskatchewan that may or may not be able to be traced, but that, like I said, that new vehicle from a neighboring province, there's no history of it in Saskatchewan, so we have no idea what happened to that vehicle in the time since it was built by the manufacturer until the time that vehicle was brought into the province of Saskatchewan. The party also referenced a study from the Macdonald-Laurier Institute that suggests Canada's gross domestic product could grow by up to $18.1 billion if provinces reduced internal trade barriers through mutual recognition agreements. I don't know how eliminating vehicle inspections would really improve interprovincial trade. That's a bit of a stretch to me, but I'm not convinced myself. Let me know if you're convinced that the requirements for vehicles inspections in Saskatchewan for out-of-province vehicles that want to be registered in that province should be removed. Let me know your reasoning. Try and convince me otherwise. But like I said, I haven't seen any good arguments so far from the NDP in Saskatchewan to remove those requirements. Our last story for today comes from Ontario. As I stated, it was a case where one party was trying to sue another party for injury suffered in an automobile accident. So lawyers can't serve insurers with auto claims just because they can't find the defendants. Counsel for car crash claimants can't simply serve their lawsuits on the defendants' insurance companies just because it is inconvenient to serve the defendants with the claim, Ontario Superior Court has confirmed. The three most important words in Ontario rules of civil procedure regarding service of a lawsuit are impractical, prompt, and may. These are not synonymous with inconvenient. Ontario Superior Court ruled in a decision on June 26. In Bigabo Mugunda versus Miller Richard et al., a claimant's lawyer sought permission to substitute service to the defendant's car insurer, TD Insurance. The court denied the request. In a motion of this nature, there's an obligation upon counsel to show that they are unable to carry out prompt personal service. Substituted service is not intended to spare a plaintiff the inconvenience or expense of personal service if the latter can be affected. Merely difficulty in serving a defendant personally is not enough. The case, which has not been decided, is about a motor vehicle accident that occurred on December 26, 2023, involving the defendant Kirsten Chomiak. A lawyer for the claimant, Antos Bigabo Mugunda, issued a statement of claim on June 19, 2024. A law clerk at the lawyer's firm directed a process server to serve the statement of claim on Chomiak. The process server made 3 failed attempts to serve Chomiak at her home between June 22nd and July 4th, 2024. All the evidence states that there was no response to the door on any of these occasions. The process server also told the law clerk he believed Chomiak may not be answering her door as she resides in a dangerous neighborhood. As the court decision explains, there is no further detail as to why Mr. McNulty, the process server, thinks the defendant would not answer the door. On January 30, 2025, the claimant's lawyer wrote to the defendant's auto insurer, TD Insurance, providing them with a copy of the statement of claim. The insurer asked for an affidavit of service showing the insured/defendant had been served. The lawyer said Chomiak had not been served, asking the insurer for Chomiak's current address. The insurer refused to confirm the defendant's current address, and yep, that is correct. There is a duty on the insurance company to protect the information of their insured. So unless the plaintiff's lawyer had a court order ordering the insurance company to provide that current address, if the insurer had disclosed the defendant's current address, they could have been in trouble with the Ontario regulator for violating the rules of the Personal Information and Protection of Electronic Documents Act, or PIPEDA. I'm sure many of you in Ontario have heard of that acronym, PIPEDA. I've taken many courses on the rules of PIPEDA and the requirements to protect consumers' information, and that's an example of why those rules exist. So the claimant's lawyer then sought an order from the court for substituted service, meaning it was enough that the insurer had been served. The insurer would then be responsible to make the defendant aware of the claim. The court denied the lawyer's request for the order, saying it's only available under limited circumstances outlined in case law. The court said the lawyer hadn't done enough to serve Chomiak. So yes, your automobile policy, regardless if we're talking about Ontario, Alberta, Prince Edward Island, Nunavut, will defend you from lawsuits filed against you in regards to the ownership operation of an automobile within certain restrictions. However, all the rules when it comes to serving and processing a lawsuit has to be met regardless of whether we're talking about somebody who's insured or uninsured, automobile accident, other types of accident, slip and fall claims. Doesn't matter if insurance companies are involved or not. The rules when it comes to the courts are going to apply regardless. However, if all the rules had been followed, then yes, the insurance company will be obligated to provide a defense for their insured, pay for the defense, deal with any judgments against them within certain restrictions, once again, because there's always going to be restrictions, exclusions when it comes to any insurance policy, never mind an automobile insurance policy. So always be aware of that, regardless of what type of insurance that you're purchasing. Those exclusions, those conditions, those restrictions, they're always going to be there. So just an interesting case. Doesn't exactly affect insurance in general. It's just a behind the scenes of claims cases, because they're always the most interesting stories for members of the general public are the claim stories. The crazy claim stories, the outrageous claim stories. Those are the ones that attract or keep the attention of the members of the general public more than dry stuff such as coverages, endorsements, exclusions and whatnot. So just a claim story, just behind the scenes of how a quick glimpse of how automobile insurance liability claims are dealt with. But like I said, if the insured had been properly served, then this wouldn't be a story at all. It could just be a regular defense for the TD insurance in this case, which they've done multiple of, as every insurance company in Ontario and across Canada has done as well. So that is it for me for today. If you have anything to comment about the stories that I've talked about today, please feel free to leave a comment. Also follow me on X. With that, if you would like to subscribe for more like this video, let me know you like what I've been doing here so far. I'd appreciate that. And until my next episode, I will see you then. Thank you.